welcome to another episode of Simplifying the Law. Thank you for joining us. If you are new here, this is a program brought to you by the government of Guyana through the chambers of the Attorney General for the benefit of the citizenry, so you are aware of what the laws are, the general provisions of the laws, and penalties or fines which may be included within these laws. As you may know, the government has a very robust legislative agenda. This year, up to August this year, 19 pieces of legislation were passed in the National Assembly, and these are modern, complex laws which require some level of technical expertise to be broken down and explained. And in light of this circumstance, the government thought it necessary to put this program together so that persons are aware of, like I said, what the laws are for their benefit, because the provisions of the legislation may benefit you in a specific way of which you may not know of, or they might contain penalties for offenses which the legislation creates, and you might not be aware of that either. But as our Honorable Attorney General says, ignorance of the law is no excuse. So that is the mandate of this program. With me today, I have Ms. 𝘕𝘓𝘂𝑚, our Deputy Chief Parliamentary Counsel at the Ministry of Legal Affairs, and Ms. Ismat Bacchus, a State Counsel at the Ministry of Legal Affairs. And they are going to help me to go through a significant piece of legislation which was enacted this year, actually, and that is the Data Protection Act. And like I said, this is a modern, complex piece of legislation. And I know, Ms. Bond, you were incremental in drafting it. So thank you for being here, and thank you both for being here. I would just give you the opportunity to introduce yourself.
Thank you, Richard. Hello, viewers. I am 𝘕𝘓𝘂𝑚, and as Richard said, I'm the Deputy Chief Parliamentary Counsel at the Attorney General's Chambers, and my main role is to assist the Attorney General and the Chief Parliamentary Counsel in managing the drafting division.
Thank you.
It's always a pleasure, Richard. So as you would have said, my name is Ismat Bacchus, and I am a State Counsel attached to the Attorney General's Chambers.
Thank you. So we're just going to get right into it. And the first question, of course, is what is data protection and why is it important?
Okay, so data protection, if I can explain a very simple way, is having the mechanisms in place to safeguard data or information. And this is to prevent data from being corrupted, from being lost, or from being misused. And so this is important because of the value that is placed on data. So I was reading an article yesterday. I had mentioned that data is the new oil. And so what oil was in the 18th century, data is now that in the 21st century. And this is because of the use of data. Now, everything around us is data-driven. It is data that drives innovation, it drives technology, it drives development. It is data that is used to develop business models. It's even data that we use to communicate on social media. And whether knowingly or unknowingly, our data is continually being processed. And so what data protection does is to ensure that there are different safeguards or different policies in place to ensure that that data is not misused or stolen. And that's because of the value that is placed on data. So that is why data is important.
Okay, thank you. And you've mentioned that there are a number of types of data or data covers a number of things. So what kind of data is protected under this act?
Okay, great question. So when persons hear data protection, they might think about all types of information being protected. But this particular legislation speaks to personal data. And it also speaks to sensitive personal data, which is a category of personal data. And this data must relate to a natural person or which is a human being. But of course, in the law, you would see a natural person. So it's just those types of data, personal data. So it doesn't relate to financial data or data relating to farming or data related to buildings, just personal data.
So, but can you elaborate on what is personal data and sensitive personal data?
Sure. So personal data is any data that can be used to identify a person, or collectively data. So it may be one type of personal data, or it could be a combination, but so long as the information could identify a person. And this person is a natural person, so a human being. So for example, a name is personal data, your address, your identification numbers, your banking information, even your email or online identifiers, for example, your IP address, even nicknames. So for example, using myself, I have a nickname, my home name. So if that is being processed, you may not see Joanne Bond, but you see my home name, then that is also personal data because someone can identify me. So it's anything that could identify you, Ismat, or myself. That is personal data. Now, as it relates to sensitive personal data, that is also personal data, but you call it sensitive because the nature of it. So we're looking at things like your race or your ethnic origin. You're looking at your sex or sexual orientation, your sex life, political opinions, whether you're a member of a political party or a member of a trade union. You're also looking at your health records, your biometrics. So those things are sensitive personal data. And if I can add, there's a general prohibition in the law with respect to processing that sensitive data because of the nature of it. However, there are exceptions to that processing. For example, as you know, the health facilities process our medical records all the time. Likewise, GCOM would process our biometrics data. So the law can provide for an entity to actually process your sensitive data, or you can consent to your own sensitive data being processed.
Thank you. And you mentioned processing of data. So could you elaborate on or explain what amongst the processing of data under the law?
Right. So processing of data basically talks about the various ways in which personal data is being handled. So for instance, your data is being collected, it's being stored, and it's even being distributed to others.
Are all kinds of data covered by this legislation? For instance, what about being processed by law enforcement or let's say GRE?
Right. So that's actually a very good question because the Act is quite extensive and it does cover a wide range of personal data. So, for instance, but coming back to that, it covers a wide range of personal data, but there are a number of exemptions under the Act. So not all of the provisions of the Act would apply to all types of data. So when you speak about data that is being collected by law enforcement or GRA, for example, that is data that's being collected to calculate tax or even protect our national security. So under the Act, those types of data are exempt from what we call the disclosure requirements, meaning that that type of data doesn't have to be, when you're collecting it, you don't have to disclose it to the data subject because obviously that would go against the entire purpose of the processing if you are to disclose. So yes, the Act does cover a wide range of personal data, but there are a number of exemptions as well.
So what are the other exemptions then?
So I think perhaps the most important exemption is data that is collected for domestic or personal use. So for instance, you are collecting data in your homes every day. You're collecting names, addresses, numbers of your family, your friends, etc. that you just plan on using just for personal use. So the majority of the Act doesn't apply to that type of data. And also there is the data that's collected, well, that data that's covered by legal professional privilege. As an attorney, you know that certain data that your clients would share with you, that's confidential. And so the disclosure requirements also don't apply to that type of data as well.
So Ms. Bond, you've mentioned that data is the new oil.
Yes, it is.
But Guyana is now entering this oil phase of the country's development, and that brings me to a question that I would like to ask you. Why is this legislation important, especially given the juncture of Guyana's development where we're at, and Guyana has been named one of the fastest, if not the fastest growing economy in the world. So why is this important now?
Great. So we actually are the fastest growing economy, and like you rightly pointed out, with the trajectory that we're on right now, great things are in store for us. So Guyana is actually behind the rest of the world, particularly when it comes to data protection. And so now is the best time, because many years ago we should have had data protection legislation because, like I said, the value of it. But apart from that, data protection is about safeguarding human rights. It is about the right to privacy. And the right to privacy is necessary because it preserves the autonomy of a person. Person should be able to say how they want their data to be used or not to be used. So that's the first thing. Secondly, good legislation creates the enabling environment for development. Once you have good legislation, investors would want to invest in your jurisdiction because data is always being shared, particularly across borders. And so one of the main concerns with investors is that if we share data, we want to develop in Guyana, you must share data. You can't get away from that. We want to know that our data is secured because our investment will be secured. And also based on the fact that we're now creating a digital economy, and we're also developing our digital infrastructure. As you know, right now the Ministry of Health is working on their information health systems. So they're trying to put all of the health information online. They're trying to digitize that to make it easier for users. We also do telemedicine already in Guyana. We also recently passed our electronic transaction legislation. We have our Digital Identification Card Act. We also have our Plan and Safe Windows Bill Act, because that was recently passed. So all of those initiatives, they need data protection legislation. And so when we passed that act, what we were doing is enabling the operation of the other pieces of legislation because they cannot properly function without that because they rely on data sharing. So now is the best time because of the move that Guyana is on. If we want to become a developed country, we need this type of legislation.
And you mentioned that the human rights of persons whose data or whose data is being captured must be protected. But what about those who are processing or doing the processing, such as, for example, journalists? How does it apply to them or help them?
Right, so if we circle back to the exemptions point that I was making earlier, so under the Act, information that's gathered by journalists just obviously for use in journalism, or even information that's gathered for artistic or even literary purposes, those are also exempt from certain disclosure requirements under the Act, because in drafting, obviously you recognize that there is a fundamental right to freedom of expression, and that's a right that journalists enjoy, and that's something that they need in order to properly do their work. So, but whilst that right does exist and the Act does try to protect that right, of course, not only through the exemptions provisions, but also through a number of other provisions that we'll discuss later on when we talk about the role of the Data Protection Commissioner as well, and certain restraints that are placed on the Commissioner when it comes to data that is gathered for journalism especially. So whilst we do recognize that fundamental right exists, like Ms. Bond would have said, there's also the right to privacy, and there's also a right to access of information. So none of these rights are absolute. And so really the Act tries to kind of achieve and maintain a balance between these rights, really.
So what I've gathered so far is, this is a lot, and it deals with sensitive matters, and it involves a wide scope of persons as well. So, Ms. Bond, if you could tell us what went into preparing this legislation.
Okay, so this legislation is very complex. And so what we use to draft this law is the General Data Protection Regulations of the European Union. And so the European Union, they've developed regulations dealing with data protection, and their regulation is considered to be the gold standard. So most modern data protection laws are actually based on the GDPR. And you would even see the GDPR being reflected in certain international instruments also. And they've also tested that piece of legislation in their courts. And so we looked to that first, and we also looked around the region, because of course when we're drafting a law, we try to get a regional perspective. So we do what is called comparative legislative drafting. So you want to see what your colleagues in the region would have produced. And so we looked at Jamaica, we looked at Belize, we also looked to St. Lucia, and we looked at Barbados. And so they have a recent data protection law based on the GDPR. We also looked at Mauritius, and we also looked at Kenya, because they are Commonwealth territories. And then we sent the legislation out for comments. And as you know, we didn't receive a lot of comments. And I think it's because of the subject matter. You know, it's not one of those spicy areas, so to speak, or controversial areas. I think everybody realizes we need this law. And so that's why persons, they read it, they realize it is sound. And so we didn't really receive a lot of comments on it. And so then it went to Parliament, and then it was successfully passed.
Yes, but I do recall one comment that we received was from a Barbadian attorney who gave the legislation high praise, actually, while it was in the drafting stage.
Yes, and he also gave the draft the high praise, but I didn't want to brag on myself.
So can you speak to who the act specifically applies to? The act mentions data subject, data processor. You know, who are these persons? Who does the act specifically apply to?
Okay, so in understanding the legislation, I would do it this way. So whose data is being processed? That is the data subject. And the data subject is a person, a natural person, a human being. So for the purposes of this piece of law, it is not the personal data of a company or any other entity. It is the personal data of a person. That is the data subject, like you and I. Then you have the users of personal data. And the users are, one, the data controller. Now it is the data controller that will determine how the data is processed and why it is being processed. They have overall responsibility for the processing of personal data. And a data controller could be a natural person, a legal person, or any other entity. And just for the benefit of the audience, a legal person is an entity that has a legal personality, so they can exercise the same rights and obligations as a natural person. And then you could have a ministry, so a government ministry, which is a public authority, can be a data controller. You could also have like a non-for-profit. You could have a beauty shop. You can have a club. So long as you're processing data and you have the responsibility for determining why, how, and when, you are a data controller. Secondly, you have the data processor. Now, the data processor is any person, any legal person, any entity, any NGO, any group that processes the personal data on behalf of the controller. So the data processor carries out the instructions of the data controller. So those are the main persons, and then you look to who must enforce the law, who must ensure compliance with the act, and that is the Data Protection Commissioner. Now the Data Protection Commissioner is the independent supervisory body for this law. And the Data Protection Commissioner has extensive powers, namely to conduct investigations, to entertain complaints. So a person can complain to the Data Protection Commissioner, and he must investigate those complaints and provide a suitable remedy. And he or she can also institute criminal proceedings in court. And there are also extensive other functions like awareness raising, issuing guidelines, providing advice to the government on data protection. So those are the main characters in the data protection law.
The main players.
Yes.
The act speaks to data protection principles, what are these principles exactly?
Okay, so the data protection principles are really just the rules, basically, that everyone who is handling personal data are expected to follow. So, for instance, you're expected to ensure that the data is being used fairly, lawfully, and of course transparently, and you're using it for a specific and explicit purpose. So you're not going off course. You have to say exactly what it is this data is being gathered for. And you're making sure that you're not keeping this data for longer than is necessary. And whilst you're processing it, of course, you have to ensure that you're maintaining the integrity and the security of the data. I mean, those are really just some of the main rules that we have.
And I heard the word lawful there. And I just want to touch on the lawfulness of processing and what constitutes lawfulness.
Okay, so lawfulness simply means that you must have a legal ground for processing data, and the legislation set out what those grounds are. So, for example, the first one is consent. So that's the easiest ground. Once someone consents to their data being processed, no problem. That's your lawful basis. But there are other lawful bases, such as contract. Now, you know a contract binds parties. So as long as a contract says that data must be processed, then the data control would have to adhere to that. So that's a lawful basis. Secondly, you have where a legislation would actually empower an authority to actually process data. And we have several of those in Guyana. So you have, for example, GCOM. So there's legislation that empowers GCOM to actually do its work. And even the Constitution speaks to the role of GCOM, and then you have other principal legislation. For example, you have the Financial Intelligence Unit. So the Anti-Money Laundering Act speaks to the FIU actually processing data. So they collect data, they process it. You have the SOCO, the Special Organized Crime Unit. So you have entities where the law enables them also to process data, and that is a lawful basis. You also have instances where data must be processed for the public interest. So a law does not provide that it must process it, but of course, once you could show it's related to public interest, then that data can be processed. And then you have other lawful bases, like for the purposes of Parliament. You have, for example, outside of the contract, for example, if there is some sort of criminal law that says that data must be processed. It's not in statute law, but it's common law, customary law. There's international law also that binds Guyana to say that we must share information, we must process information. So those are some of the lawful basis of processing data. And it's important for data controllers to be able to identify what is the lawful reason for processing this data. Just in case it is questioned as to why are you processing this or that, you must be able to point to, this is my lawful basis for doing what I'm doing.
Well, right. So the lawful basis must exist, but you've mentioned a word there, and I know that specific word is going to grab a lot of attention. So I just want to ask the question directly. Does a person have to consent to data processing?
No. So consent is not always required in every instance, as Ms. Bond would have just went through. Once there is a lawful ground that supports the processing, then consent isn't required. It's really only required where there is an absence of a lawful ground. So for instance, as she would have discussed, there are several pieces of legislation that require certain data to be processed. And so when the data controller and the data processor, they have to comply with these acts, and so they wouldn't require consent to go ahead and start that processing. But if, for example, they intend on using the data in some sort of untoward way, some way that could cause the data subject to suffer some sort of intrusive sharing of their data or something like that, then they would require their consent.
And now, taking all of this into consideration in terms of lawfulness and consent and all of that, we know that persons' data are being processed all the time on a daily basis. As we speak, persons' data is probably being processed,
yes.
Right? So how does the law empower, as you would have mentioned, the data subject with respect to the processing of their own data?
Okay, so this legislation in Part 3 closed the data subject with rights, and there are several rights. Now, I'm just going to go through some of them. So, for example, you have the right to be informed of why your data is being processed, who is processing the data, if your data will be shared, and to whom. You also have a right to access. This means you have a right to actually see your data that is being processed. So I could give an example of myself. I can go to the personnel department at the Ministry of Legal Affairs and say, can I see my employee record? And they must show me my file to see what is in there. You also have the right to object to your data being processed, and this is only in certain instances, because as we pointed out, there are lawful bases for processing data outside of you consenting. So even if you object, the data controller may have a duty in law to actually process your data. So while you have a right to object, the data controller may not necessarily stop processing your data. You also have a right not to be processed by automated means, and this speaks to being processed through a machine. So oftentimes, there may be a machine that is actually processing your data and actually come up with certain decisions based on that processing. And so you can say, well, I don't want that because it may have legal ramifications for you. You also have a right to what is called data portability. And this means having your data in a machine-readable format that can be used by several entities. So for instance, GRA is processing my tax data, but my tax data may actually be needed by another entity. So if, for example, the bank may need it to do some sort of transaction or some due diligence. And so I must be able to go to GRA and say, can I have my data in a format that I can now share with the bank? So I don't have to gather up that information again and then give it to the bank. So those are some of your rights as a data subject. Now I must mention that you also have a right, what is called a right to erasure, or the right to be forgotten. And of course, we want to hear that in this part of the world, but in Europe, this has already been tested. So there's actually case law on this. So this means that if your data is being processed, you can say, well, I want my data to be deleted, right? And the data controller can delete your data, and then you've forgotten. And this is often with respect to search engines. You know, when you type in your name, you may see certain things about yourself, and you don't want that anymore. However, that is not an absolute right. It's not automatic, because, for example, that data, like I said, may be connected to actually a lawful purpose. So the data controller, by law, is bound to process your data. Or, for example, that data is needed, for example, for you to present a defense or for you to exert a certain right. And so it's not an automatic right to be forgotten. And so those are some of the rights of the data subject.
Okay. What about the data subject being provided with information when data is collected?
All right, so as Ms. Vaughn would have said, that is a right. A data subject has a right to be informed about the processing. So I think it's sections 20 and 21 of the Act speak to the type of details that the data controller or data processor has to share with the data subject. So for instance, when they collect the data, they're supposed to inform the data subject of the purpose of the processing. Why am I collecting this data? What's the intention behind it? The categories of data that are being collected as well. What type of data? Is it everything under the sun, or is it just these specific types? Who the data will be shared with. Of course, that's very important to a lot of persons. You want to know where your data is going to end up. Because of course you're thinking about confidentiality at the end of the day, how long the data is intended to be stored. And of course, as Ms. Bond, I think, mentioned earlier, the data subject has a right to lodge a complaint with the Data Protection Commissioner about the processing of their data, and as well they also would have a right to access the data or even request that it be erased or rectified, for example. So there's a number of rights under that.
Now this act applies to Guyana, domestic legislation, but you know, as you would have mentioned early on, data, it's wide ranging and it covers a number of things, including, for example, social media. And sometimes if you're engaging with somebody on social media, they might even be in a different country, or it might be necessary to have data to facilitate international trade and cooperation, and you have two different jurisdictions, and now you have persons or the subject's data leaving Guyana and going to another country, or coming from another country to Guyana. So does the law speak to protection when it leaves Guyana?
Right. So it does. It does address what we call cross-border flow of personal data. So because, of course, as you would have just discussed, transfer of data across borders is happening every day and in different ways. And especially what comes to mind are these multinational corporations. So, for instance, banks that have your personal data, and they have different branches in different regions, especially. This is where the protection of data becomes very critical, and that's why there is really a general prohibition under the Act that prohibits the transfer of data to another state or territory outside of Guyana, except where there are certain appropriate safeguards in place and an adequate level of protection, so to ensure that the data subject's rights will be maintained in that state and territory as well. So, for instance, when this will be assessed on a case-by-case basis. So in each instance, you will look at whether or not that state or territory has data protection laws in place to ensure the protection of the data subject's rights. And they'll also look at whether or not they have a regulatory body like our data protection office to, oversee the application of these laws, and of course even things such as a code of conduct for data controllers or data processors. So generally it is prohibited, but once these safeguards and these adequate measures are in place, it is allowed.
You've mentioned protection principles earlier, and you've also mentioned procedures in which must be followed for the processing of the data. So, but what I want to touch on is enforcement, the enforcement measures under the Act, and how do we ensure that persons' data or the data subject's data is not misused and is protected, and how do we ensure that processing is done in accordance with the legislation?
Okay, so as I mentioned, data is very valuable. And so when a person's data is misused or when it is sold, which often happens, it's a lot of money. So it's big business. So this law is equipped with enforcement mechanisms. And for instance, the Data Protection Commissioner, that is his main role, to enforce the legislation. So there is a right to complain to the Data Protection Commissioner. So if a person feels that their data is not being processed in the manner set out in law, they can make a complaint to the Data Protection Commissioner, and he or she must entertain that complaint. So one of the things that the Data Commissioner can do is actually issue enforcement notices. And this is where the Data Protection Commissioner will write to the data controller or data processor to say this person has made a complaint and inquire further. And in these notices, based on the information gathered by the commissioner, he can actually stop them from processing a person's data, whether it's for a short period of time or just tell them to stop completely. And they must comply with that enforcement notice because it's actually a penalty to not comply. All right, so apart from notices, there are also criminal law provisions within the Act. And so they are offenses. So for example, it's an offense to actually procure someone's data without the permission of the data commissioner. It is an offense to actually sell someone's data. It is also an offense to actually acquire the person's data or process it without the data controller's permission. And so one of the things the data controller can do is, if he's aware of this, he can actually go and get a warrant from the High Court, and the High Court judge will issue that warrant, of course, naming the police officer who must execute that warrant, and they can go to the premises of the data controller and actually enter. As you know, a warrant enables you to actually enter the premises. They can actually search for documents because they must build a case, and they can seize documents. Of course, my colleague, she would have mentioned journalists and their rights. And so the Data Protection Commissioner and the warrant is actually restrained when it comes to that data. So if it concerns journalism, then he would not be able to seize that, because of course you don't want to suppress journalists, artists, or other literary personnel. You don't want to suppress the arts, right? Likewise, when it comes to attorney at law and communication, they would not seize that documentation because it breaches attorney-client privilege. But otherwise, they can actually seize the document. Now, I would have mentioned the offenses. Now, I would say that this legislation has dissuasive penalties, right? So the penalties actually range from $20 million
Wow.
to $500 million, and that's a lot of money, right? And that's because the value of data. So one information about me would probably make somebody $10 million, right? More so if they have like my bank card, they have my other records, you know, what can't they do with that information? More so, for example, national security, those sort of data. Billions of dollars. So I know persons might be alarmed at the fines, and there's also jail time. So you can have at least 5 years imprisonment if the matter is tried in the magistrate court, or at least 10 years if tried in the High Court and you're found guilty. Now, I must mention that the offenses under this act, it works with the Cybercrime Act. So the Cybercrime Act already provides for data theft, or the illegal acquisition of data. And so when person read this law, they must also read the Cybercrime Act for the offenses. The Cybercrime Act also speaks to illegal acquisition of data. It speaks to illegal access of data, and it speaks to the misuse of data. And so those offenses work also with the protection of personal data. There's also forfeiture. So the court can actually forfeit the documents that are actually used once it's connected to the crime. They can order the destruction of those documents. Of course, someone can petition to the court and say, well, you should not destroy the documents because what is contained in it, I needed to, for example, assert a legal right or claim. And so in that instance, the court would not order the destruction of that document. And so those are some of the enforcement mechanisms under the legislation. I must also mention that with respect to body corporates, there is a special penalty for a body corporate because they make a lot of money. And so if a body corporate is found guilty of any of the offenses under the Act, that body corporate can be liable to a fine of 4% of their annual global turnover of the preceding year. And we say it is global. So it's not just what you make in Guyana or what you make in the US, but globally, what is your net worth? What did you make last year? 4% of that is the fine. And we put 4% to make it standard or to make it proportionate for all types of body corporates. So whether you're small, medium, or large, it is the same percentage. So those are some of the enforcement means.
Okay, thank you. And what about where someone claims to have suffered damages or distress due to the actions of the data processors or controllers?
Right, so as Ms. Bonner said, data really is the new oil. So persons definitely have a valid reason to expect that if the data controller or the data processor's actions harm me in some way, say for instance I'm the data subject, then I should be entitled to compensation. And you are, because the Act expressly states that. I believe it's section 97(1) that states that once any person who suffers damage or distress as a result of some sort of contravention of the Act by a data controller or data processor is entitled to compensation from that data controller or data processor. So persons shouldn't worry that they would be left without a claim. They are entitled.
Okay, and I know we spoke a lot about protection and processing, but from a practical perspective, what really needs to be in place for the processing of data to be regulated?
Okay, so first of all, the act will have to be commenced. So this act is not enforced at the moment, and this is because of the complexity. This is a new area for Guyana data protection, and there's certain things that must be in place before the Prime Minister, who's the subject minister, can actually commence the law. And if you look at the commencement clause, it actually empowers the Prime Minister to set different dates for different provisions of the act to actually come into force. And that's because we want to be practical. If I can give the example of Jamaica, Jamaica passed their data protection law in 2021, and it is only December of this year that they've set for the act to actually come into force. It doesn't mean that we're going to be like Jamaica and take so long, but that's just to show the realistic nature of these types of legislations. It can't just come into force just like that. Apart from that, once the law is in force, the president will have to appoint someone to be the data protection commissioner. So that's one of the first things that must be done. And then that person will have to also be equipped with the right staff for his office, the right tools, because of the extensive powers of the commissioner. The commissioner is the person who will actually regulate or administer the sector, and he has oversight. So one of the first things he or she will have to do, and I keep saying he, but she, right? I think because of how we draft law, sometimes we say he, but she. But if you have a male or female there, so whoever the person will be, will have to do extensive awareness raising. Because data controllers, they must understand what is their role under the act, because they will have to be registered. And because of time, we didn't go into all of the details. So for example, if the data control is not established in Guyana, but wants to actually process the data of a Guyanese or a person in Guyana, then they would have to have a representative. So those are things that the controller will have to be aware of. They will also have to be awareness raising with the processor. What is the role of the processor? Because as I mentioned, the processor actually carries out the instructions of the data controller. Now, if the processor processes data on their own, there's a penalty for that. Likewise, the legislation provides for data protection officers. So I didn't go into that, but you will have ministries, other public authorities, businesses appointing persons to be the data protection officer. And that person is really to ensure that the act is being followed by their respective entity. So those are some of the practical things. Now, when it comes to the legislative side of things, the Data Protection Act is a principal legislation, but we need to pass subsidiary legislation, and that is regulations as well as orders. So the minister is empowered to pass regulations, and for this law, you would need regulations. Kenya has regulations already. Jamaica is currently finalizing their regulations, because you need to set out what is called the procedural aspects of the law. So you need forms, you need to know about fees, you need to know how consultation must be done, because the law speaks to that. So all those things will have to be fleshed out in regulations, because the principal law only sets out the framework, but actually the meats, the potatoes, and all of those things, they will be in regulations. Apart from that, the Data Protection Commission is also empowered to pass what is known as soft law. So this speaks the guidelines, it speaks the code of practices. So those are things that will also have to be published by the Data Protection Commissioner, so that persons in the sector will understand what is data protection and what is required by them. So as you can see, it's extensive work to actually bring this legislation on board. And so persons must be aware of that. And bearing in mind that these things, it takes time to actually set the infrastructure in place if you want it to work properly, because you don't want to just commence it and then you don't have the regulatory infrastructure in place, which is policy, which is all the legislation, all of the moving parts. Because once the Prime Minister says it's time to commence, you want to be able to benefit from the law. as a data subject, I don't want to assert my right to, let's say, rectification, and then that's not in place on how the data control is supposed to go about doing that. He may not even know what is that right because we didn't do public awareness. And so it's not fair to me as a data subject because I can't get the benefit of the law, and it's not fair to data control because he's going to be penalized for something he didn't know. So even though we say ignorance of the law is no excuse, at the end of the day, we want a law that is efficient, that is effective, that actually does what it's supposed to do.
Right, good. Well, thank you both for this comprehensive, elaborate explanation of the Data Protection Act. It's quite a bit, a lot went into drafting the legislation. That's evident for sure because it covers a wide scope of things and takes into consideration all things necessary. As we're done in the end of the show, I would just give you the opportunity to share any final thoughts or comments that you may have. Starting with you, Miss Bond.
Well, I think I've said a mouthful. Well, what I would say, I mean, is Matt and I only give you a snippet. So this is a very, like we said, it's a complex, it's complicated. I understand because I have to do my own research. And that's what I would encourage persons to do. Read the law for yourself and go online. You know, take some time from the Facebook and whatever is happening and actually, you know, do some research for yourself so that you can be familiar with the subject matter. So that's what I would encourage persons to do.
Yes, definitely. I would piggyback off of what Ms. Bond said. I mean, this is definitely a technical piece of legislation. It's very involved, and there are high penalties, high fines involved. So it's definitely very important for persons to make themselves aware of the provisions and just look out for when it comes into, you know, operation.
Well, thank you both for being here today to go through this piece of legislation. I think you have done an excellent job. You know, I've definitely learned a thing or two. So that brings us to the end of the program for today. Like I've mentioned at the beginning of the show, this is an initiative by the government of Guyana through the chambers of the Attorney General to educate and enlighten the citizenry on laws that are already passed or laws that are being passed, and you could see why from our discussion here today in relation to the Data Protection Act. You could see why that is necessary. Modern, complex laws are being passed, and new laws are being drafted every day, and you know, to take into consideration the circumstances under which we're living. You know, Guyana is rapidly developing, and we need this type of legislation. We need data protection legislation, for example. So this program is brought to you by the compliments of, or with the compliments of the government of Guyana, to ensure that you are up to date and kept abreast, because you know, if somebody breaches a provision of the Data Protection Act or one of the offenses and they're charged 200 million,
yes, they're out of business.
But they can't say they didn't know, right? Okay. Thank you for watching. Until next time, I am your host, Richard Bainey. With me today, I had lovely Miss Joanne Bond, our Deputy Chief Parliamentary Counsel at the Ministry of Legal Affairs, and Miss Ismat Bacchus, State Counsel. Thank you.